Yes, Mr.
Lord,
Agarwal.
I'm very sorry, my lord.
No, no,
Item number 14.
Hmm.
Lord, I have fixed, my lord, today the Honorable Chief Justice has fixed a
You had
Yes, sir.
circulated a memo.
Lord, I need retail accommodation, my lord.
No problem.
Lord, can it be fixed, my lord, 16th of December, my lord?
Why so long? 14, 13
My
matter.
lord, in the meantime, I'll be not there, my lord. I have some.
We'll. When are you going out?
I'm not going immediately, my lord.
Then we'll have it in the first week of November or second week of November. 13 matter. That's why we don't want to give a longer time.
Then, my lord, your lordship will kindly fix it on 20th, my lord.
20th. Okay.
I'll not be there enough.
17th,
Okay.
my lord, I have a
Within the second week, 10th to 14, any date what is
10 to
comfortable,
14.
you can just give
10
it.
to 14, not possible.
Not possible. 3 to 7,
December.
17 to 21, any date.
December.
No, November.
November 2020, my lord. 20 or 21. Any day.
2020.
I'll be there.
You fix up a date whenever you are here. 13 to 16. Mr. K. Agarwal, Learned Senior Counsel, appearing for the appellant in
I'm in item number 14, my lord.
criminal appeal number 279, 2013. Submits that the matter be not taken up today as he is engaged in another parthead matter before another bench. The other learned counsels for the learned counsel for the other appellants have also prayed that the matter be taken up on any other date. Also, the learned counsel for the respondent has not objected to the prayer. Accordingly, registered to list this matter again on 18,
Come back, my lord. Anyway, my lord,
19,
25th number, my lord.
on 25/11/2025. The matter being the appeals being old pending ones, no further adjournment would be granted.
Only one thing I would like to point out here, my lord. 14 and 15 we are representing. The other two matters has died already and all that. And
If they have died, it's gone. It's gone.
but where two are concerned, my lord, we have to.
Do it.
I'm obliged.
Obliged.
It is your lordship. Lordship, yesterday lordship had most kindly allowed criminal petition for listing.
Not come.
My lord, for tomorrow, my lord. My lord, I had omitted to write down that the date is on 1st of November. And henceforth, my lord, it will got I pray for yesterday's prayer only, my lord, for tomorrow. Obliged, my lord.
Convenience on my part. Not prepare, my lord, the item number 10 and
Then
item number 10, my lord.
the serious matter.
Yes, my lord. Out of that, one item 10 is I am appearing, my lord.
Have you taken the consent of the Standing Council CBI?
But I've just now.
No. Then we let the matter be called. We have heard this matter also.
My lord, my difficulty is that I have not. Sorry, my lord.
Mr. Chomuan need not go through the files. He will take 5 minutes. I have also gone through yesterday night only. So we'll let the matter be taken up. We'll see. 13 to 16 already are adjourned.
I'm obliged.
May please, your lordship.
All listing. If there is some urgency, just mention, otherwise give it. She'll give the dates. Two zero. Why? No adjournment. Next. It was adjourned on the last date on your prayer. You are for the appellant, petitioner. It was adjourned on the last date. We can't help it. You do the matter. It's a matter of 2014. Thursday, Friday. Thursday, maybe Friday.
Mr. Lordship, 30 of the daily list.
13.
Yes, 30.
Already adjourned.
My lord. A.K. Dotto is here on behalf of Mr. A.K. Dotto, my lord.
A prayer is, have you taken the consent of the...
Yes, my lord.
A prayer is made on behalf of Mr. A.K. Dotto, Learned Counsel for the respondent number 2 on the ground that he is indisposed. A prayer is made on behalf of Mr. A.K. Datta for adjournment on the ground that he is indisposed. Prayer is not objected to by the learned counsel for the respondents. Petitioners, registrate to list this matter again after 2 weeks on a date to be fixed by.
Please, your lordship. Lordship, praying for listing of a criminal petition, my lord, for motion. Oh, my lord, if possible.
Why? What is the urgency tomorrow?
Sir, the matter is completely a civil dispute and
When is the next date fixed?
30 of this month, my lord. So I pray.
Deeply obliged.
Why? Oh,
Affidavit, Lordship. on-
have you taken the consent? Oh, what is left here? He is retiring now. We fix this matter today so that we can do it before Mr. Soikia's client retires. If both of you are agreeing, I have nothing to say.
Seventh, my lord, let me fix.
As prayed for by the Learned Council, Mr. Day, S. Day, Learned Council for the respondent number 6, prays that he be granted a week's time to file an additional affidavit in the matter. Prayer is not objected to by the Learned Council for the petitioners. Accordingly, register to list this matter again on 7th would be difficult. 10th. 10th.
Please, your lordship. Mention.
It's a, we'll have to dispose it of. We'll have it on 11th. 11.
Beg to make a mention for. Obliged.
You are there? State is not here, not a formal, not a party. But the Learned Council, none has appeared for the parties on call. So the present revision petition has been instituted, assailing the order dated 29/5/2012, passed by the Principal Judge, Family Court, Guwahati, in FC bracketed criminal CRL dot bracket over number 57609, awarding maintenance to the respondent herein and her child. Also, the respondent herein, the respondent herein had approached the Principal Judge, Family Court, Guwahati, by way of instituting an application under Section 125 CRPC, praying for maintenance for herself and her minor child. Full stop. They said application was registered as FC bracketed criminal dot 576/09. So the learned family court, upon perusing the evidences coming on record, was pleased, wide judgment dated 29/5/2012 to direct for was pleased to allow the prayer of the respondent herein for being awarded maintenance. For sub, the family court awarded an amount of ₹3,000 to the respondent herein and a further amount of ₹3,000 to her minor child. Also, it is to be noted that this court, while entertaining the present application, was pleased, wide order dated 31/8/2012, to direct the petitioner herein to continue to pay to the respondent an amount of ₹5,000 till the disposal of the present revision petition. Also, the learned family court, upon perusing the evidences coming on record, had drawn the following conclusions. Page 18, A to A. So basing on the said conclusions are drawn, the learned tribunal, learned family court had directed for payment of maintenance as under a orderer, B to B. So this court has perused the conclusions drawn by the learned trial court, learned family court in the light of the evidences coming before it. Also, this court finds that the petitioner herein had not disputed the solemnization of his marriage with the respondent herein, and further, the paternity of the child born out of such wedlock was also not disputed. Also, although it is brought on record that the respondent herein is staying away from her matrimonial house, the evidences coming on record justifies such action taken by the respondent herein. Also, the family court, basing on the evidences coming on record, had found that the petitioner herein had means to provide for the maintenance of his wife, and that is the respondent herein, and his child. So they said conclusions drawn by the learned trial court has not been disputed by the petitioner. Also, in view of the above position, this court is of the considered view that the conclusions drawn and the maintenance granted by the family court would not call for any interference. Also, accordingly, the petitioner herein is directed to pay to the respondent the maintenance in terms of the directions passed by the family court vide the judgment dated 29/5/2012. Also, the interim directions passed by this court vide order dated 31/8/2012, directing for payment of ₹5,000 as maintenance by the petitioner to the respondent herein stands vacated. The petitioner shall
Please, Your Lordship.
pay maintenance at the rate of ₹6,000 with effect from the date of the judgment of the learned trial court, that is with effect from 29/5/2012. The areas would be paid to the petitioner, to the respondent by the petitioner within a period of 3 months from today, and thereafter shall continue to pay the said amount regularly. Yes,
I'm sorry, I mean, we need 2 weeks time, Lordship.
I pass the order. Your name? Want me to?
Actually,
You are appearing for the
we
petitioner.
have Mr. Z Khalid,
For the petitioner.
petitioner, Your Lordship.
Heard Mr.
M.H. Ali.
M.H. Ali for the learned counsel for the petitioner. None appears for the respondent. You passed the amount. Whatever the interim was there, we have vacated it. 6,000 from.
Earlier conducted by Mr. A.
I
Khalid.
can't help it. We have adjourned the matter 2 times, 2012 matter. How long would you want this court?
Because
Not
we-
even a single minute. I had already adjourned this matter on 24/10.
We have lost the contact of the petitioner, Your Lordship.
Fine, I have passed the order. You comply. Otherwise, you go. Yes, next. I'm sorry. This is not the way conduct.
Item number 30 for adjournment
3-0.
30, yes.
Oh,
Yes, Council M. Deb, actually,
okay. A prayer is made on behalf of Ms. M. Deb, learned counsel for the petitioner, for an adjournment in the matter on the ground that she is indisposed. Prayer is not objected to by the learned counsel for the respondent. Registry to list this matter again after 2 weeks on a date to be fixed by.
Please, Your Lordship. Lordship, I'm here in this matter. I have been appointed as the amicus in this case, my lord.
Hmm.
Even been served a copy of the petition as yet, my lord.
Okay, we'll help you.
My lord,
Hey,
there
file
is-
to DDR. You take this file, read it. After some time, we'll take it up.
registry may be directed, my lord, to give me.
Forget the registry, you read this file. I'm giving you my file. What better file you can get? Read it. We'll take it up at 2 o'clock. Dutawazat Matidigo. Mr. Fukon, the charge was under 323/341, convicted. When it matter went up to the appellate stage, 341, he was acquitted. Only 323. Make a prayer. We'll consider what can be done. right? It's a case. Now the offense, I think around 18, 19 years have passed down. Make out a case. We'll consider what can be done. Read it. 2 o'clock. Yes, Mr.
My
Kumar.
lord, we are ready, my lord, our team. My lord, with all respect.
Last day, Mr. Kamar had problem. Today,
my lord.
the CBI council has
My
problem.
lord, problem has called.
So this court should be
Now we
unanimous.
are here before your lordship on the last.
No. We should be
We are
very
here, we are
balanced.
here, they are here from Chennai also.
Okay, we'll take it up after some time.
But a bit early is.
Whenever she is there, just make a
No,
mention.
actually, for them, I'm saying, my lord.
Subject to my lord. Lord, would it proper for me to seek a date?
Why you have come from Chennai? We will entertain you. We'll see that your visit is fruitful.
I've been very hospitably treated here, my lord.
That's it.
So
It's a very
it's been
hospitable place. Don't worry about it.
only aspect, my lord, we have not seen you. I have to confess, an admissible confession before your lordship, that we haven't seen the original records. So I thought, my lord, subject to your lordship.
See, when you have somebody like Mr. Kamar
no,
leading you,
that-
you need not even think
Still,
about it.
then-
He has already taken up a preliminary objection
Yes,
here
Yes.
with regard to the very maintainability of the proceedings. So that's what I was very eager to hear today.
Obliged, my lord. I'm
So
grateful, my lord.
if you want it, when do you want it?
Any date subject to my lord's
It
convenience,
can't go beyond the second week of November.
not second week, my lord.
First
any-
week.
First week. My lord, it's convenient for 17th, my lord. Now, we just thought, my lord, on a lighter note, if it's a Monday, then.
I got it.
We.
Why not 10th? 10th.
An-
10th.
Any other date of. Lord, if-
We can have it on 3rd also if you want. But that will be too short.
24 will be a good person.
No, 17th.
17th, my lord,
But
subject.
get a confirmation from the learned.
I'll do that, my lord,
CBI.
and report it before the court. If
Okay,
I-
I've accepted your prayer, but no further adjournment.
No, further adjournment.
Because we accommodated Mr. Kamar because he wanted to place certain judgments in.
He is coming.
And we just thought, my lord, we'll enjoy the hospitality a little more.
Please
at
do
the-
so.
At the client's expense. And thought
He has already retired.
he's retired, my lord. He's
What about any departmental proceedings
no
against?
departmental
No
proceedings.
departmental
So the admitted case, my lord, no departmental proceedings.
And pursuant to this, everything has been stopped.
But to only 3 or 4 important interests.
So we'll hear Mr. Kamar on the maintainability first. That's what I think you took up the Dasdev. The sanction is not there.
In this case also, another case,
So,
same point. In this case, only just one no consent letter is.
I was eager to hear you on that.
I'll do my.
Because-
But tomorrow is the more wider one. How it was taken up.
Okay,
But,
17th we have agreed, but subject to madam's confirmation. You can leave.
Here.
Mr. Kamas Jr. would be here. He can coordinate with that.
Well, she has agreed that
No, but still, just get a
we
get a-
will
get a
verify and
clarification.
inform the court, my lord.
Just
only-
Mr. Chaudhary can inform the court.
2-3 questions of law, my lord.
Whatever it is, I'm ready.
Grateful, my lord.
17th, huh? 17 लिखित हुई है, subject to correction, as prayed for by the learned counsel for the parties, for the learned counsel for the appellant. A registry to list this matter again on 17/11/2025. The learned counsel for the parties are at liberty to peruse the original records in the meanwhile. Full stop. No further adjournment would be granted in the matter.
I'm grateful, my lord.
Fine. Why?
But item 9 and
As prayed for by the learned counsel for the parties, a registry to list this matter again on 4/11/2025. No further adjournment would be granted. Which one, Mr. Daka?
11, madam.
11, huh? 11, they have taken time,
Yes, yes, on Fort Miller.
Port. Yes. Yes.
Lordship, on the last occasion, we added in the cause list.
Okay, fine. You are there.
Takes-
You argue.
Lordship.
The learned trial court found everything in your favor, but there was two notices, 2-6 and 22-6.
Yes.
And if it is 2-6, then you filed it beyond the period
Beyond
of
limitation.
limitation.
That is the case, Lordship.
So now establish that
Lordship.
your only plea is that the council who has issued the notice may have erroneously put the date 2-6 in place of 22-6. Or it was a manufactured document by
It was the
the,
manufactured.
but you have not led any evidence to that effect.
Yes.
Then
Yes, there is
then-
no evidence disputing.
what
However,
should-
Lordship, my submission is that when documentary evidence is there,
the documentary evidence is also of 2-6. It was brought on record. The
But
evidence
Lordship-
is on record.
but Lordship, in check, so far as Negotiable Instruments Act is concerned, it is not just notice which is important, but proof of issuance as well as proof of receipt.
Arre, that is something which you should bring in on record. There is nothing on record here. I don't find you cross-examining the DW.
Lordship, admittedly so. But
So I
Lordship,
don't
if-
think so. We should have, this is a, what should we do? Now, this is a cemented position now.
but Lordship, if this proposition is
You should have
accepted-
examined the council who had issued it. You have not examined.
Ideally, Lordship,
Learned Council, Mr. Kothari was examined, but on a different point
on
altogether.
a different point.
That
that
is with
was-
regard to that agreement.
Lordship.
So-
No, but Lordship, my case, if I have I've prepared
Please, these are all tentative views. Don't worry about it.
table highlighting what is our limitation and what is their, what are the dates that they are relying on.
See, this date of issuance is not to be, there was a document produced wherein the signatures of the council was there, a notice was there,
Lordship.
and see, it's probable because the check was dishonored on 23/5.
Fine.
So issuance of a notice on 2/6, and see, there is a evidence on your evidence also that the draft was ready on 2/6. So what should we do?
Interestingly, what happens is during cross-examination, the document is shown to the person there in the doc. So most likely the notice dated 2/6 was shown, and that is how the evidence was led.
That is your
Because what
your
was-
fault, your default. We
Yes.
can't help it.
No,
Now
but
this has
it-
come. I don't have an extra sense to perceive things.
Lordship.
I can only go with the record. And the evidence is that your evidence is that you had asked your counsel to prepare the notice. He prepared the notice, you saw it on 2/6. What time? Not there. I went through the case records. I don't think.
Lordship, just only there's only a narrow point. If I can sustain, that's fine. Otherwise, my case does not sustain, Lordship. Lordship, on one hand, there is this that has been issued by us, which is dated 22/6/2007. There is a receipt which shows that we've issued that notice, so we get that benefit of section. Then there's an acknowledgement also which shows that on 28/6 the person duly received the notice. So after that, there's a reply also 12th July. I'm not getting into that. Now, on the other hand, there is a notice which they have purportedly produced dated 2/6/2007. They have not been able to prove the. been able to
Why?
prove
Is the onus on them to prove
Yes,
that?
Lordship. As
Show me.
per section
Show me.
103, no, Lordship, if we go by the Evidence Act also. Yeah. Act, if there is a firstly, if I prove that there was an issuance of check and it was dishonored due to whatever the reasons that are contemplated under 138, then the burden of proof is on the accused. Now, Lordship, if this is allowed, for example, let's say this proposition is allowed or this practice is allowed.
Hmm.
Tomorrow, in all cases, one notice would be sufficient. One notice which is slightly of a different date, if that is produced, that would be enough. Otherwise, they should
Just show me the evidence available on record disputing this position.
this
then-
admittedly so, Lordship. It has not.
Then you're
that is
fair.
right.
You're fair. You're a counsel, you're officer of this court, you're really fair to this court. But in absence of that, how can I ignore that evidence?
Really. Only thing is, Lordship, if section 61 of the Evidence Act, let's say there is a certain evidence documented.
Mr. Counsel, I understand your proposition, but for that, for me to examine, there has to be something on record.
Something to dispute.
Dispute that. There is no dispute. Why should I create a dispute on your behalf? If I'm wrong, kindly correct me.
Lordship,
If there
otherwise-
was even something here, and see, this is coupled with your deposition
Yes,
that your
the
counsel had
cross-examination.
prepared it on 2/6, no time given.
Lordship.
So
Served
the
up for corruption.
presumption would be that, yes, that is the notice. Now, why 2/6 notice was sent on 22? No evidence.
No evidence on that. But there's evidence that yes, postal receipt is there.
That is different. That is a fresh one. That is a fresh one or a new one, you don't know. Why?
But it can only be construed.
It
from-
cannot be construed in absence of a dispute being raised.
Lordship, generally, the accused ideally should be able to prove that not only did he receive a different notice, but
See,
from that
it's
date.
not a question of receiving a different notice. He received a notice. And you yourself have built up the case for him by saying that the notice was prepared on 2/6.
126.
Then that's your evidence on record. There is nothing beyond that. Then you dispute that this is maybe a mistake of date. Examine the advocate. You have not examined the
The
advocate.
advocate. Given that, Lordship, the court ideally should see that if there is.
Why
complete
should the
chain-
court go and do the homework for you? You should do the homework for yourself.
Ideally, Lordship.
Now, I've tried to find out if there is anything disputing the position. I'm sorry.
No, there's no
nothing.
dispute. I have to fairly submit, Lordship. There is no dispute in part. Only thing is that whether oral testimony will sustain over the established documentary evidence that has already
You have built up, you have cemented the 2/6 by your evidence itself.
by my evidence.
I'm sorry. Next time,
Lordship,
some other case. You are Y Kothari.
if I could.
Dispose of. I'll pause you. Just go run through the list and then pass the order.
No.
What is your ground? Huh?
Very tired. I have seen, my lord, the
The 13-2 notice was also served on you. That day I missed that. I found it out.
You lordship kindly see. My lord,
Nothing, no merit.
no merit, my lord.
No merit.
I am agree with you. My lord, only submission, my lord, the person, my
Hey,
lord.
it was some prevention of
My lord, the
federal
person, my
pressure.
lord, my lord, came from UP. And he, my lord, started a grocery shop in Haflong. Now, my lord, he is tasteless. At the time of filing this.
Oh, that day courts will trace it.
My lord,
Don't
exactly,
worry.
my lord. My lord,
That
at
the
the
court-
time of filing.
Oh, is he alive?
My lord, that is the question, my lord. My lord, at the time of filing, my lord, he was, my lord, 65 years, now 77 years. My humble submission, my lord, before you. My lord, fine may be imposed, my lord, here. In fact, my lord, regarding merit, my lord,
Nothing is there.
nothing, my lord.
It was only that 13-2 notice which would have
Yes,
given
my
you something.
Now, my lord, as
That is
per
not-
my calculation, he is carrying 77 years. The last stage of his life, my lord.
Don't say that. You have a prevention of What we do is we uphold the conviction, but we will give you the Probation of Offenders Act and the fine you deposit. But Mr.
Manaf.
A. Manaf, learned counsel for the petitioner, also heard Ms. A. N. Begum, learned additional public prosecutor appearing for the state trust. Also, the present appeal has been instituted with the leave of this court, assailing the order dated 5/12/2012 passed by the additional district magistrate, Dima Hasav, Haflam in CR case number 819/96, convicting the petitioner herein and appellant herein under section 7/16 of the Prevention of Food Adulteration Act 1954. Also, the prosecution case in brief is that on 25/6/96 at about 11:30, Food Inspector T. Chong Loy visited the shop of the appellant herein at Haflam and collected sample of besan to me. Italics koidiba. Bol. So they said sample on collection was sent to the public analyst for chemical examination. The public analyst on analysis of the sample so forwarded opined that the same was a old sample infested with fungus, adulterated and unfit for human consumption. The analyst forwarded his report to the local health authority. Basing on the said report of the analyst, it is found from the records was forwarded to the appellant herein under the provisions of section 13(2). The said notice was duly received by the appellant herein. Thereafter, an offense report was submitted in the matter against the appellant. The trial court, during the trial, the prosecution examined 2 witnesses. The appellant herein was thereafter examined under section 313 CRPC. On conclusion of the trial, the learned trial court was pleased by judgment dated 5/12/2013 to convict the appellant herein under section 7/16 of the Prevention of Food Adulteration Act 1954. On a such conviction, he was sentenced to undergo imprisonment for 6 months and also for payment of a fine of ₹1,000, in default to undergo further simple imprisonment for another 1 month. Mr. Manaf, learned counsel for the appellant, after attempting to argue the matter at some length, has submitted that the conclusions that the materials available on record, that the collection of sample as well as the submission, the forwarding of the report of the analyst above the analysis of the sample so forwarded to it has been so done strictly in accordance with the Provision Act of 1950, and there exists no material to dispute this said position. He has fairly submitted that the conviction of the appellant herein would not mandate an interference. However, he submits that the appellant is presently around 77 years of age and is suffering from old age ailments. Accordingly, he prays that this court would show a leniency in the matter. Ms. A. N. Begum has not disputed the submissions made by the additional public prosecutor, has not disputed the submission made by the learned counsel for the petitioner. First of this court, I have heard the learned counsel for the parties and also perused the materials available. So the materials brought on record, this court has perused the lower court records and finds that the samples were collected from the shop of the appellant herein strictly in accordance with the provisions of 1950. So thereafter, the samples so collected being forwarded to the public analyst, the analysis thereof reveal the sample to be unfit, adulterated and unfit for human consumption. So the said report was forwarded to the local health authority. So the records reveal that the report of the public analyst was forwarded to the petitioner hearing under the provisions of section 13(2). Also, and the petitioner had duly acknowledged the receipt of the same. Also, however, the petitioner had not exercised his right to have the sample kept with the authorities, analyzed by the Central Forensic Laboratory. Also, in view of the above position, it cannot be above position. It is apparent that the samples as collected from the shop of the petitioner was adulterated and unfit for human consumption. It was also found to be infested with fungus. So accordingly, in view of the materials coming on, evidences coming on record, materials, this court is of the considered view that the conviction of the appellant herein by the learned trial court under the provisions of section 7/16 of the PFA Act would not mandate any interference. Having noticed the next one, having drawn the above conclusions, this court finds that the offense was committed in the matter by the appellant herein on 25/6/96 when the sample was collected from his shop. 19 years has been found to have lapsed since the date of commission of the offense in the matter by the petitioner herein. Also, this court also notices that the petitioner herein has not been prosecuted for a similar offense either prior to the one involved in the present proceedings and or during the pendency of the present proceedings. Also, it is also found that the petitioner has been litigating the matter for the last 12 years in the present appeal before this court. So, in view of the above position, this court is of the considered view that the petitioner herein is entitled to be extended with the benefits under the Probation of Offenders Act 1958. So, accordingly, the sentencing of the petitioner stands modified, and instead of imprisonment, the petitioner is directed to be extended with the benefit under the Act of 1958. Full stop. Baki, my dear. Before the, now it is the, in Haflong we have a judicial court now, or it is still the, Mr. Chutia is still the judicial. So district judge, additional district magistrate, these cases are considered by the CJM only. So it will be now which court? District Magistrate Dimahasa would be now session judge, before the session judge. Within period of 2 months.
Highly obliged, my lord. Right.
Have you seen the medical report?
Has gone through, madam, but I'll see.
Mr. Sharma has gone through.
I'll just,
Medical report does not.
there is nothing. Kindly see only
417, but
That-
that basis is not there. 376 he has been acquitted.
Yes,
And
acquitted,
the
acquitted.
very fact of the physical intimacy, if you look into the medical report, not there. Get hold of somebody from Mr. H.R.A. Chaudhary's chamber. Mr. A. Chaudhary's amicus curiae.
Yes.
If you can just send a message. Mr. Begum, Ms. Begum, if you can just send a message. We'll take it up after some time. Yes, madam. Huh? Can't help it. How sick is he? I accommodated him on last occasion. It's a matter of 2014. Shows us win very badly. Because Miss D. Bonagoy passed away, I accommodated him. Okay, we'll have it. Aji Mangalwar, no? We'll have it on Thursday. If not, I'll appoint somebody and then proceed with the matter. So now very narrow. Ask Mr. Gohai to do his homework and come back. Your judgments, that list I could get over one or two others, I could not even find out.
I have a copy, I will give it to
Ah,
you. So it,
Thursday. As prayed for by the learned, well, a prayer is made on behalf of Mr. P. Gohai, Learned Counsel for the petitioner, for appellant, for the petitioner, for an adjournment in the matter on the ground that he is indisposed. Prayer is not objected to by Mr. K. Bachaji, Learned Counsel appearing for the respondent. Registry to list this matter again on इस तारीख को बोलेंगे 30/10/2025
30,
30. Any problem, Mr. Bachaji? 31. No further adjournment shall be granted in the matter. Yes, Mr. Vatago.
One is your lots of criminal. So both were. Your lordship. Slightly.
He heard this matter.
Hard, but your lordship.
I read.
Of the disciplinary process.
Can I take up this? Because this is not allotted to me. It's a
Your lordship,
pure
there-
civil.
There is a judicial order, your lordship. For
But how do you justify this quashing? I don't think so. As far as I understand, if there is something, then it's a case for
Lord.
that much criminally understand. I can't understand beyond that. So
So far as
we'll dismiss this.
washing is concerned, your lordship, I admit, your lordship, that
Then you admit we'll close it and we'll put this before the appropriate bench for your.
no, your lordship, why I am, your lordship, in
Hmm.
of that, your lordship, because your lordship, the FIR in the criminal case, your lordship, that shows, your lordship, the FIR is entirely based on, your lordship, the enquiry report, your lordship.
Be that as it may,
Specific,
be
your
that as it may, this brings some criminality on record, FIR. So it's not a case to be quashed. What is the stage? Stay, there is a stay.
No, your lordship, there is a stay since 2000, your lordship.
Oh, that stay we are vacating today.
No, your lordship may take up both these matters, your lordship can dispose of it. I will not take
I'll
much
not
time,
touch
your
that. I'll touch this first.
Your lordship will kindly see.
I'm now in the criminal jurisdiction, so I'll take up the criminal thing first.
But your lordship is an expert in both, your lordship. That's your lordship.
Mr. Bothakur,
Okay.
it's not long that I have shifted this side. We know the meaning of that word, what it is. Maybe a year down the lane, I may forget. But it's too fresh for me now. Yes.
Page 11 is the FIR, and your lordship will kindly see that with due honor, I, principal so and so, that Seniram Datta made a huge irregularity during the service as Bahana College for his departmental proceeding draws against him by the director higher education. The report of the proceeding concluded gross negligence, so and so.
See, this is again, so this is, unfortunately, I have read that file also. This is not a allegation in air. There is some basis.
Yes, your lordship. But your lordship will kindly see the manner in which ultimately this proceeding was conducted, your lordship.
Now, your lordship, so far as disciplinary proceeding is concerned, your lordship, it cannot even stand, your lordship.
That's a different thing altogether.
So, your lordship, if entire the enquiry report goes, then what will remain, your lordship? Their whole case is based on the enquiry report and finding of the enquiry report, your lordship. That's the point, your lordship. Now, even if your lordship decides, your lordship, now your lordship will kindly see the fundamental defect in the disciplinary proceeding is that the charge sheet has not been issued by the disciplinary authority, your lordship.
See, there is a latest decision of the Supreme Court in that line that
Lordship.
311 only envisages, my Lord Justice Dottos,
Lordship.
recent case. It says that 311 envisages imposition of a penalty
Lordship.
should be by the appointing authority.
Lordship.
So the view now that is coming is that proceedings can be initiated.
No, your lordship.
How far? I have not very deeply gone into that, but
Lordship will
we had
kindly
this
see-
notion.
Problem is this, your
we
lordship.
had this notion under our disciplinary rules, section rule 8,
Lordship.
that it can be only by the disciplinary
Disciplinary
authority,
authority.
and the disciplinary authority has been defined to be the appointing
Appointing
authority. But now the Supreme Court is taking a
No, now your lordship will kindly see if it is issued by your lordship, the inquiry officer, what will happen there? He has already formed his opinion, your lordship, by issuing it.
that's a different thing altogether.
That's what
That's
has,
a different thing. I'm
that's
not
what has-
touching it.
that's what has happened here, your lordship.
Mr. Bhattakur, we'll have to, even if we allow that application, the writ petition of yours on the technical grounds,
Sure.
that will still not amount to affecting this.
That, your lordship, I have already submitted that so far as the criminal petition is concerned, your lordship.
We
Yes.
will close this, let the criminal thing take its own course. And with this, we will consider separately. We agree?
I can take up today
No,
itself
no,
and
no.
finish it
No,
off,
no, no.
because I will take hardly 15 minutes, your lordship. There's
You
nothing
take
much
15
to-
minutes. This 786 computer will take some more time.
Your
I don't want
lordship,
to do that.
No, it is not 7.
Mr. Mohanto will take a whole day. I know that.
Your lordship, that is.
Yes, Mr. Mohanto. Mr. Mohanto has many things to argue.
My only.
What
prayer,
about the criminal? We are closing it
Your
today.
lordship will kindly see, my only prayer, your lordship, is to take up both the matters.
That criminal case will be, by this time that would have been closed.
And today, if I open this also, I'll be technically right in opening it up for the investigating agency. Now, after 9 years, 10 years, is around 70 plus now.
Lordship, around 75. Because it's 2010, your lordship. He retired in 2010, your lordship.
And the proceedings were of
2010,
12.
12, we have, your lordship, filed this petition.
The penalty was passed after your retirement.
After my retirement dismissal, your lordship. And your
That was
lordship will kindly
initiated-
see, this charge sheet was issued after my retirement, your lordship. The
It can be recovery,
lordship,
can't be dismissal, because they, fine. If it is, I've not checked the that dates because I don't want to check it, because don't touch it. I'm not a white file now. I'm a red file now. So I'll not touch white files.
so your
So-
lordship will kindly, and finally, your lordship,
But Mr. Monto, if that be the position, if he has retired, the severance of the, when is the allegations
is your
pertain
lordship,
to?
is the allegation, your lordship, prior to my retirement, your lordship.
Within 4 years of your retirement. So the proceedings is proper. 21, 22, comply. Then he retired. You are doing this proceeding under the Assam Discipline Appeal Rules. Show me the provision under that wherein you can impose a penalty of dismissal. Director. Get the director.
Fact, your lordship, one judgment I have found, your lordship, on rule 1 of the Assam pension regulation, your lordship, division bench of this honorable court says, your lordship, as per the rule 21, once I retired, your lordship, thereafter to continue the proceeding, they will have to take the approval of the government.
No.
That is that
No,
judgment.
no,
I've
there
seen.
is a decision. If the offense is within 4 years
Sure.
from the date of your retirement, so they can initiate that proceeding if on the date of the initiation, 4 years prior to
Yes.
that.
No, your lordship will kindly see that.
But how can
I'll
they
show-
impose a penalty of dismissal upon you? They cannot. Want out. So we'll close this. We'll hear that. Hear that means before the bench to, I'll put it tomorrow,
If-
Brihaspativar, Aji Mangalbar, Thursday. I'll observe therein that both the parties have expressed urgency, so the matter will be taken up on Thursday itself. And I'm closing this.
Your lordship can take up this also, your lordship. Because your lordship, it will not take much time for it, this honorable.
No. I'm not touching that. I'm only with this. Red
Ultimately,
file.
my case, your lordship, so far as the criminal petition is concerned, that what I have found from the petition also, your lordship, I am late entrant to the case, your lordship. That your lordship, that this is the case, your lordship, since it is purely based on this enquiry report, your lordship. Therefore, your lordship, this proceeding, your lordship, if this enquiry report
See,
goes, what
this
will happen?
inquiry report, maybe technically you may have a case there,
Lordship,
technically.
Lords,
But the materials which have come out here reflected that will justify a criminal proceeding.
on
What
the
I'm
case-
saying is, therein, technically, maybe you are right. The penalty of dismissal could not have been issued on you. Because you have already superannuated, it would have been a question of recovery of the amount which they have quantified as a loss. But the materials which have come here, at least on a prima facie examination, I can't go beyond and
Lords,
justify.
Lords.
It's that there is some sort of a misappropriation, misuse of power by you. Mandating the FIR, validating the FIR. So what we do is we close this criminal petition and direct the petition to be listed on Thursday if both of you agree.
Lords. See, it will be
Tuesday?
difficult, your
Tuesday?
lords.
Okay.
I'm not bragging on this, but
I have urgency, your
because
lordship.
I know, I might not realize the problem that in after a long time.
Mohanto, if it is not an executive nature of, engagement, he may not be interested. But if it is a daily wage engagement, he will be
Lordship,
engaged.
it looks like your lordship.
It's a daily wage engagement. he will
I have
be-
to realize the person's the feelings after the time. That is why I have
But
not considered.
It will close. Criminal petition close. WPC 129. Also, heard the Learner Council for the petitioner, for the parties. The Learner Council for the parties have expressed extreme urgency in the matter and have prayed that the matter be listed for final disposal at the earliest. Also, as agreed to by the Learner Council for the parties, a registry to list this matter before the appropriate bench on Tuesday, on 4/11/2025. Also, an endeavor for 25. Also, the Learner Council for the parties are at liberty to renew their prayer for early disposal in the matter on the next date of listing.
My lord, there is a I prayed, my lord, there is a stay order in the criminal, my lord. That should, my lord.
That will be vacated
automatically
today.
get vacated.
By evening, you will get the order. Don't worry.
March 31st, 1960.
It was still today. Today, everything is, stars have come in your favor.
Oblige, your lord, deeply oblige.
Oh, did I click it?
But that notice part is concerned.
Yes, yes, Mr. Ogadi.
You took only on 2 points. First point is that Aztec. In this case, Aztec marketing, it is a fact that they have not. That person was interested, he was authorized to institute.
Where is your this plea before the learned trial court or
That
before
was-
the appellate?
That was raised, that point was raised.
Where is it? How was it considered?
Because that point, ultimately, that point was allowed.
Where?
I'll go through that. At page 13. The learned trial court held that found that it admitted that the Borkakoti was getting and also admitted that exhibit 2 or 3 was handed over to him. The said two checks were drawn by the accused not in dispute.
Yeah, just a moment, Mr. Ogadi. Yes, which page?
Page 28, para 13. And that the said two checks were drawn by the accused and also not disputed. However, it is clear that same was undated and given as a security. To determine this plea of this evidence on record, PW1 has denied the safe plea. There was nothing on record to show that defense has extract anything to substantiate. Hence, the evidence of DW1 is looking while his cross-examination that he had not written on the overplay of the check. It was given as security, not he has filed any document. He had given the said check as a security. That the said check exhibit 1 does not, the checks were given as a security as the answer found that from the material on record it is found that admitted work order by the accused being exhibit A1 on being go through that, so it is found that accounts that this point was not discussed at all.
Not discussed, not taken. Not taken by you. Okay, let's see how it was. Where have you taken it in the appeal?
Even otherwise, Lordship,
Will not permit you. This is a revision only.
the revision in that case, I am on the order 38, what is it, section 138B. 138B, what does it say? 138B clearly shows that the payee or the holder of the check in due course of the check, the case may be, makes a demand for the payment of the said amount of money by giving notice in writing to the drawer of the check within 30 days from this one. So here in this case, the amount was written in the check. That amount, the total amount comes about only 18,81,784. But demand was made for 18,91,000.
That
demand.
demand of 18,91,000 is explained in
No.
para 2.
No,
Yes, you read para 2.
even
of
if,
the notice.
even if it is explained, that cannot be. Because it is specifically the.
It is severable.
It is
That
severable.
much work the court can do.
No, Lordship, it is a, because I am in the before revisional court, it is in a law point. This court can very well decide that point. Because in that case, demand was made as against the rupees 18,91,000, not 18 lakh.
Come to the notice.
Notice at page 3, or at page, notice in para 3 of the said notice.
Where is that? Where is that notice in the record?
Notice is not, I'm showing it is in the record.
Pay dated, notice dated,
Notice
24
that
3.
18, that was
24 3.
24/3/2009.
Come there.
Come there at page 3
By this notice, I hereby call upon to immediately repay the aforesaid outstanding amount of rupees, balance amount of rupees 18,91,000.
No, you come to the para 1 of that notice.
Para 1, all right. If that para 1, it was additional amount, this is only a verbal, even if it is a verbal or otherwise it is admitted also, even then that cannot be, because check was specifically mentioned for 3 lakhs and 3 lakhs and 15 lakhs 81,000 something. So not that one. 15 lakh 81,784. Check was specifically stated. Check was not given for 18 lakh 91,000.
The check is exhibit.
2 and 3,
So there were 2 checks,
2, 6,
3 and 15.
15.
So total is 18,
18
81.
lakhs 81,000. 784. But demand was made for 18 lakhs 91,000. And that part by the demand notice dated, para 3 will go, not other things. And because additional amount was asked for, this separable amount has been specifically demanded, 24%. That 24% will come. Yes, court can give a double of the amount, the check amount also. But demand has to be made as per the check amount only, say check. Judgment of the Honorable Apex Court says, speak the same thing.
You refer to these 2 judgments.
Lordship. But this,
It is 2025
Lordship. And it
and
refers,
2000. Let us take up 2000 first.
here in this case, 2000, this judgment was referred in the 2025 judgment. Paid money of the amount refers to the check amount, very specific. Hence, in notice, the demand has to be made for the check amount. Otherwise, the notice will be bad. If besides stating the check amount, other claim is such interest or damages or surges are also to be separately by this notice. It will be not treated as a bad for that reason. For that 24% has a cost and compensation has been already demanded. That's 24%.
Just a moment. Rainbow color. Suman Sethi.
Suman Sethi versus Ajay Kumar Satra. Surreal.
Same proposition.
Same that I am given.
This is from Calcutta High Court. Okay. Then,
So here in this case, demand has to be specific.
Okay.
Based on the check. Separate amount can be demanded. And here in this case, she has already demanded 24%. So that 20%, if the trial court allowed it, there is no problem. But demand has to be made only based on the specific, what it is written on about the check. Nothing more. Nothing more, nothing less. And these two, this judgment, this case was referred, this judgment of 2025 refers to 13 judgments. Here all the cases, same proportion has been given, finding has been given. In this case, check amount was sold, it was more than the check amount. 9,000 something. 9,290 rupees was demanded more. Although check amount was made for 81,000, check amount was given only 81,000, 18 lakhs, 81,784.
okay. What is the purpose of a notice, mister? What is the purpose of a notice?
Simple. It is a given a scope to the persons that
Make up
this, you can repay that loan.
Now, in the body, the notice cannot be read only the last paragraph. It has to be read as a whole document. If I read the whole document, notice as a whole document, a layman, what would be his understanding?
In the case, demand
You
has
forget
when-
the case. You
in this
come to
case,
the
for us,
facts.
he will come.
You come to the facts. In this notice, if the person, a layman, reads that notice, what would be his understanding? That Mr. Bhagwati is demanding the check amount, plus he has also referred to another 9,000 rupees, which he was to pay, which was supposed to be paid by check or by cash subsequently. So even if it is taken as 1891, the notice makes it apparent that the payment of the check is for 1881. Now, if you make that payment of 1881, no further proceedings can be initiated under 138. That is the end of the matter. If Mr. Talukdar has to accept, he'll have to go before the civil court. In that view of the matter, there is no error as far as this tentative view of this court is concerned with regard to that notice.
My point is very simple. Given up 9,000 was assured to be paid by him.
It is just the manner of writing.
No, it cannot be because that 2002 judgment specifically says it cannot be an
So
obligation.
this is the only point you are taking.
One point. And
Second.
even otherwise also this point. Second point is also there is in cross he admitted that he was not authorized. The authority has to come.
Where do I get that?
That I can read that cross-examination of that persons. Cross-examination of that persons.
Of
PW1. PW1.
Devasis Borkotugin.
I do not remember if I have submitted or exhibited the authority of letter by any document.
Wait. Where do I get it?
At
AS Marketing is a complainant and I am one of the partners of so and so. Three partners. I have filed the case on behalf
Let us
of.
come to the prosecution part of it.
If I have exhibited the authority letter of any document authorizing file this case. Is a registered partnership firm. I have not filed the registration document.
This is important. There is a specific bar under section 69(2) of Partnership Act.
Partnership Act to some. Yes.
That point also. That
But here it says that the only requirement here in 69(2) is for a firm to institute a proceeding. It should be a registered firm. And the partner or partners who are there has to be shown in the list.
is- that-
Registered.
that
That
document
is
is not-
satisfied here.
That document is not there.
Have you disputed that?
Here we have disputed.
Where in
We
the
have only
appeal,
crossed-
let us see in the appeal.
No, the crossing it is.
Okay, let us see whether that was the ground taken in the appeal.
Yes, that was the ground.
Appeal memo. Where have you taken that ground?
When otherwise statutory bar is there, that means it will act. 69.
Cannot be, it's only registered firm.
But the registration has to be proved by the complainant.
You have not disputed that. You have not even taken a plea that this is not a registered firm.
We have not, even if it is in cross-examination that was put to him. In reply, he replied that he did not.
He
find it.
replied that we are a registered firm, we have everything. That is the end of the matter. And in appeal also,
But my main point is only on the check. That amount is, it differs. Demand amount is differed. One, and even the 69 bar is, 69(2) bar is there. And he was authorized. That authority has to be there.
have you taken that ground in the present proceedings?
Yes.
Let's see how you have taken it.
That is page 10, 5. Ground 5. For that the complainant filed a petition complaint under section 69 of the Partnership Act 1932 as the said partnership firm Messrs. So and so is not a registered firm.
Okay. Anything more? So these are the two grounds. Okay, we'll stick to this. Yes, Mr. Talbot.
What is concerned, check amount has been clearly been stated.
Mm.
An additional balance of 9,000 worth.
Mm.
Where we can get at that fund was for
It is severable.
that Lordship has already gone through it. Enforceable debt that has partnership deed is concerned. That has not been brought on record. Rather than a trial code. Marketing is a partnership.
It was a partnership firm.
That has been stated by the complainant.
Complainant. No, you have stated.
I have stated, madam.
Three are there. And
But whether it is registered or not, that has been not stated.
it's a registered firm. In your deposition,
That
it's
is deposition, I don't,
it's a registered firm. But he says that you have not brought the registration certificate on record.
that most probably has replied, I do not remember or something. Legally enforceable debt. Already they have 6 months imprisonment was there. That was set aside
By the appellate.
by
court.
the appellate court, the 19 lakh. Still rising of the court, punishment
Now it's only the payment of the amount.
or only payment of the amount. Aforesaid judgment. Trial their plea was that that has been negated.
Okay.
But see, one point. State evidence also.
Civil suit for the purpose of?
Take amount.
My very covered.
That is,
There is no bar, Lordship.
There's no more.
no, there is no bar. But that even if some due is there, they can say serial recover through the civil suit.
Okay, we'll consider. We'll pass the orders today.
Awesome.
Few matters left. After that, I'll pause the order. Breakout.
So the appellant was convicted. Then 417. Please.
Madam Chaudhary, you are appearing for whom? You are Mr. B. Bora. Why did you appear last time? We had to appoint a amicus curiae in this matter. Oh. Oh, but now that he is appearing, okay, fine, no problem.
Judgment.
Okay. What is your ground?
Grounds, my lord. One of my ground is that the delay in lodging the FIR. Check in the judgment also, my lord, at page number 12 of the judgment. Held by the trial court at page number 19, para 12. I have gone through entire evidence on record. I have also heard learned counsel for the both sides. Before proceeding for discussion of evidence of this case, it is noticed at the outset that though the LS occurrence first took place on 22/8, but the complaint in the present case was lodged as late as on 1/10/2009. Just after 1 year. So mere delay in lodging of FIR or complaint petition for discarding the evidence of witnesses. But the fact remains that when an FIR complaint petition is belatedly lodged and no explanation for such delay is offered or discernible from the materials on record, the court has to be alive to the possibility of prosecution witness exaggerating account of the offense and causing occurrence by involving innocent with guilty ones. In such cases, the court must guard against the possibility of prosecution witness to implicate persons or fasten along with guilty ones. As discussion took place, the decision of the court also not reflected anywhere in the judgment. This is one of on the part of delay of. Yeah, in this case, my lord, the LAS incident took place after the exhibit 1, my lord. Exhibit 1 is the complaint which was forwarded from the learned court of Zem Walpara, the police station, and of this complaint. So, Dudnoy PS case number 158/09 under section 376, 417, 341, 313, 511, 506, 34 IPC was registered. 76 was also there. And
so basically, you were convicted under 417.
only in one section, that is 4. Because in the complaint also and in the recorded IPC also, The victim alleged that I promised it has become a regular affair. Also written,
But she was a minor.
no, my lord.
I have not disputed that.
The MO says that she is 20 years.
It's just an opinion. The victim girl from very beginning, she is saying that she is a minor.
Yes, my lord. In this complaint also, she stated herself to be 16 years. And while in 2009, she was 16 years. And in the year 2013, she becomes 18 years. And my lord, her statement recorded under section 164 also, she stated 6. But the MO, that part is also there, my lord, in the judgment itself, that lordship will find page 21, para 16 of the judgment, my lord. Here it says age of the victim girl is about 20 years.
Mr. Goswami, Madam Chaudhary, misconception of fact. Now it's only 417, no appeal other than that. So that can come in only if there is that consent was on the basis of a misconception of fact, right? Now you go through paragraph 37 onwards. Mr. Goswami, Ms. Chaudhary, whoever it's, para 37 onwards. Can you just read that? Oh, please do so.
Turn back to the case in hand.
Hmm.
Had given her consent on the that her marriage was with the accused, but there is nothing to show that manner.
Just make a note of this
Yes,
line.
I've already outlined it. Your Lordship. They were married persons, or that he had. When the consent obtained, admittedly, the victim gave consent for the said act. That on being promised to marry, she gave consent. Your Lordship will kindly.
No, go ahead. That is clarified.
Admittedly, she was a major girl, as asserted by MO of the case in his evidence. Therefore, her evidence that she had given consent of hard to believe. Therefore, even if the consent given by her misconception
So
of fact,
this misconception of facts goes. Now you come.
above discussion and consideration, there is no difficulty in not obtained under any
So this is
court. Your
so if how will cheating come in? 417 come in.
Lordship, fact remains that in her state, certain different.
Fine.
I may be-
Whatever it is, whatever her remarks be, if the thing was not under a misconception of fact that he would marry her, she had surrendered herself.
Finding of the learned court on the basis of what she has perhaps submitted to my respectful understanding. Now, if you Lordship will kindly turn to my paper book, it is page 91 of form of recording deposition.
There is a paper book made.
Yes, sure. No. There's no paper.
Page? There's no page 41. It ends at page 31. What is it? Just tell me what it is.
PWD1, the deposition of PW1.
Victim's deposition.
Victim's take. করে দিও না, বা I'll take my learned friend's help to read this.
No, it's okay. It's a deposition or the before the police?
Yes, Your Honor. 164.
Before the court, my lord.
No,
Yes,
before the
Peter.
trial court.
Before the trial court.
Just a victim. Hmm. Yes.
আমি ঘৰত কাম কৰা 6 বছৰ কাম কৰি আছিলো। মাহত 300 টকা বন্দবস্ত
Doctor.
আহি 5 বাৰ 5 বছৰ
5 বছৰ তাত
5 বছৰ
কাম
কাম কৰি আছিলো।
কৰি আছিল, হা?
বছৰ মই
বছৰ মই কৰিছিলো।
doesn't
কৰি
really
আছিলো।
তাৰ 5 বছৰ আগত
মান
তাত আছিলো।
5 বছৰ পৰা আছিল ন?
তাত আছিলো।
আসামীজন আসামীৰ লগত ভাল পোৱা আছিল। আসামী
মোক ৰেপ কৰিছিল।
কৰিছিল। 5
Along with 4 to 5 persons tried to forcibly oust the petitioner number 6 mother, who is Bhagwanti Jeshwar. But on that day, Your Lordship, having no other relief, the Bhagwanti Jeshwar filed an FIR before the Bhangar police station, Your Lordship. Then the police arrived in the spot and they tried to settle amicably. It's a civil dispute matter, Your Lordship. But even though she was allowed to stay, but she was
Where is this land situated?
in Tarun Nagar, Your Lordship.
Torun Nagar.
Yes, Your Lordship. Your Lordship, on 30/10/2012, Your Lordship, again, Your Lordship, the Bhagwanti Jeshwar filed a complaint before the Assam State Commissioner for Women, Your Lordship. Subsequently, Your Lordship, what happened, Your Lordship, the police did not take any action since it's a civil matter, Your Lordship. The complaint, the respondent number 2 and 3 filed a complaint, Your Lordship, for the Judicial Ministry, Your Lordship, on 30/10/2013, Your Lordship. And the petitioner got the summon, Your Lordship, to appear before the court, Your Lordship. But after receiving the notice, Your Lordship, the petitioner have held meeting by inviting the respondent number 2 or 3, Your Lordship. On 19/11/2013, Your Lordship, the meeting was held, but the Krishna Jeshwar, who is the respondent number 3, did not appear meeting, but he was called by the secretary for several times, but did not appear. But again, he was asked to appear for the amicable settlement on 29/1/2014, and on that day a resolution was passed, Your Lordship. Your Lordship may come in page number 26, Your Lordship, and answer 5, Your Lordship.
So the complaint was lodged by Sudama Agarwal.
Sudama only, Your Lordship.
Jaiswal.
Yes, Your Lordship. But in this resolution, Your Lordship, the respondent number 3 have settled amicably that they would allow to stay the aunt, who is the mother of the petition number 6, Your Lordship.
Now, what happened after the complaint was lodged?
Complaint was lodged, Your Lordship, but the respondent failed to comply with the resolution, Your Lordship. They did not withdraw the case of the complaint petition, Your Lordship.
Which resolution? Page?
The complaint petition is on,
No, I got the complaint petition. Where is the resolution?
it's on page number 26, Your Lordship.
26.
Operative part, But Nagar Unnayan Committee, Your Lordship.
No, why are they before this court challenging this?
The complaint was filed against the petitioner, Your Lordship.
Oh, against them.
Yes, Your Lordship. They are a member of the Unnayan, Tarun Nagar Unnayan Committee, Your Lordship.
But the allegation is that they tried to forcefully occupy the residence.
Your Lordship, it's true that the petitioners have went to visit the petition number 6 mother, but it was never intention of the grabbing any land, Your Lordship. They just want to settle amicably between the petition number 6
Who is
mother.
who is Krishna Jaiswal? The
Krishna Jaiswal is the son of Madan Jaiswal.
and what is the relationship with Sudama Jaiswal?
Sudama Jaiswal is the son of Shyamal Jaiswal. Your Lordship, Bhagwati Jaiswal, Madan Jaiswal, and Shyamal Jaiswal.
What is the name of Sudama, mother of Sudama Jaiswal?
Mother of Sudama is not written, Your Lordship. Father of Sudama is Shyamal Jaiswal, Your Lordship.
Now, who is the aunt here in the
There is
page
Bhagwandi
26?
Jaiswal, Your Lordship.
Huh?
Bhagwandi Jaiswal. Bhagwandi Jaiswal, Madan Jaiswal, and Shyamal Jaiswal are the son of Sadev Jaiswal, Your Lordship. And they are the sibling, Your Lordship. And Krishna and Sudama are the sons of Madan and Shyamal, Your Lordship.
But Sudama is not a party to this agreement.
Yes, Your Lordship.
Then
But Your Lordship, the case complaint was registered on 30/10/2013, and the resolution was on
that is only with Krishna.
29/1/14, Your Lordship.
That is only with Krishna Jaiswal. Yes, Mr. What is this?
There's a private dispute.
Private dispute, huh?
My lord, regarding the Board of Revenue's order is there. Earlier name was mutated in the name of Revenue, my lord. Two is regard.
Hmm. Hmm.
Two is the owner of the land.
Hmm.
And they went to that particular plot of land and destruct the boundary wall. That is the allegation, my lord. And only in respect of
Boundary wall.
that is only there. But otherwise, it is a civil dispute case from the affidavit filed by the respondent number 2 also.
But this
Regarding destruction of boundary,
Boundary
only
wall.
that party only is there, my lord. That allegation.
and
is
the
there,
grabbing of the land.
my lord. And the land has already been mutated, order has been.
And what did the magistrate do when he received this?
To issue notice to the person.
Oh, 156.3, he can direct for a police investigation.
my
Has he done anything in this? Where is the
That
interim
only
order
the-
passed? When was the interim order passed here?
Your Lordship.
20?
20 February 2014, Your Lordship.
And where are the depositions made by you before the tribunal? Where is the copies of the deposition?
Lordship, in
You have made depositions before the trial court?
receiving a notice, Your Lord, this petition, Your Lordship.
No, the depositions would be by the complainant.
Complainant, they put, they have taken the initial deposition, Your Lordship.
What is that evidence? Show me. They went to file an FIR, police did not register the FIR. What is the situation as on date? Yes, what is your ground? What is your ground?
Your Worship, the case is that the land dispute of the co-owner, and
But the allegation is that you had gone in, broken the wall, put a fresh boundary wall there in the land. Who gave you that power?
Worship, we have already denied in our.
Denied that, you go and deny
Right,
before the complaint, before the court below.
We are just trying to settle amicably between the two parties. Your Lordship.
Amicably settlement not occasioning from 2014. 11 years, whatever settlement, would you go before the tribunal, before the lower court? Yes, Mr. Chutia, what do you say?
File the petition for dismissal of.
Dismissal of the, huh?
As the complainant has examined,
Huh?
process was issued.
Process was issued and it is at that stage they came here. Let it go.
Matter here, but
There is an allegation of your trespass into her land. That's a criminal offense. Lekha, heard?
And two judgment, Your Lordship, in this matter.
Yes.
Priyanka Srivastava, Your Lordship, I rely on paragraph 20.
Paragraph? Oh, this is 156. That is for the court to do. It can refer that complaint. Any magistrate empowered under section 190 may order for such an investigation. That means investigation by the police. This will not help you. Then what about this?
Paragraph 10, 11, 12, 15. Paragraph 10, 11 also.
10, 11.
11, 12, 15.
This is with regard to compromise and the continuation of proceeding. Here, Sudama has not compromised.
He himself will come.
That is a different thing altogether.
Your Lordship, in this case, what happened, Your Lordship? Only Jaiswal, she. against
I know,
Krishna Jaiswal,
that is a civil dispute of the matter that we'll not go into. In so far as you are concerned, you are not concerned with who is occupying the land, who is the inheritor. You are just social workers. You tried to come and make about a solution. In the meantime, you exceeded your jurisdiction. You broke the wall. You went inside to a private land. Who gave you that?
Totally fall, Your Worship.
That's why that you go and establish it there. The other part, it's not for the criminal court to look into. You get your instructions, what they are doing, how are they paused. At 2 o'clock, we'll dispose of the matter. Mr. Chutia, you need not be here, we'll pass the orders. We are dismissing it, asking them to go back. If they, in the meantime, receive instructions to withdraw, fine, very good.
Have legal loss. Where under DG Act, where the petitioner has been directed 7,000 per month to the. Initially, that complaint was filed by the Malad party, which is at page. Years of marriage, Malad. Proves that she was.
What are the reliefs given? 16? Oh, that, okay.
The complaint itself, my lord, disclosed that she actually left on her own because there is no specific allegations as such, my lord. The marriage for 3 years, around 3 years.
Talak.
Talak was also, subsequently, yes, petitioner has given talak to her, my lord.
But that was considered.
Communicated by registered post.
That was considered that there was talak-e-asan. Three talak. Tin talak.
Yes, 3 talak, ma'am.
Or that, no.
That is in this India gap.
Together you gave 3 talak?
1 month, my lord,
Gap.
notice was given.
Okay, where is the resolution of the dispute? Before the talak was given. Conciliation between the parties.
Conciliation was there between in the Gaon Panchayat level, man, that was done.
That
But
has
she had
been, that has
refused
not
to-
been established by the court.
For reconciliation, man.
Now, what is the situation today? What is the situation today?
Still living separately, my lord. because-
Separately. You have accepted the divorce.
Most probably.
Accepted. If the divorce is accepted, then the only thing would be to provide for you're married again. Till her remarriage, you will have to make a provision for her. That's all. I think that's the Muslim law. After the marriage, there has to be a provision made, huh?
That implies, Daniel Litimus case is implies in the respect of 125 proceeding, my lord. Not in
Yeah, what is the relief given? 7,000.
7,000. That
But maintenance will not be there after divorce.
divorce.
It's a, you will
as
have
per
to make a
Daniel-
provision for,
Provision.
have you filed any case for maintenance? Where?
125, yeah.
There is a 125 proceeding.
That
Get me the details at 2 o'clock.
actually, as per the DV provisions, I don't know. There's
This DV will not survive. If there is a,
Yes, my lord.
now that divorce he is
Now,
accepting.
I'm coming to that one. Even when filing a DV case, that 125 proceeding that is filed by the.
That is, that there
should
is,
be on record.
no,
on the
there is no
DV.
bar. There is no bar. There is no bar.
But all details must be there.
Fine,
while filing the
when
complaint.
we'll take we just take the instruction at 2 o'clock. If the, how can a maintenance be continued even after divorce? Because after divorce, a Muslim wife is not entitled to maintenance. She is entitled to a provision for sustenance till her remarriage. He'll have to make a payment, a lump sum, so that she can continue.
Daniel Latifi's case, my lord. Thereafter, it is seen that the maintenance, Supreme Court allowed the maintenance.
Or allowed after that. Oh, I'm not
But that
updated.
is, but in provision means that some amount has to be provided or it has to be paid in monthly. That is their money.
Whatever it is,
Or sufficiently
something, but
all-
it will not be in a form of a maintenance. It will be a form of a sustenancing, so that till she remarries.
But at the same time, in DV, so far as proceedings concerned, she has to disclose all the proceedings that is pending or she has filed against the petitioner.
Okay, we'll check up, Mr. Chaudhary. We'll have that.
She has filed also.
Can you get it by 2?
That is not there in the complaint in philosophy court. The law, my lord, actually.
So, Sigma?
That is the law. Shall appeal, my lord.
Hmm.
Appellants have sentence. Was for 3 months.
Hmm.
A very, very simple case. There was some scuffle and
Hmm.
but
You will have to take me through the evidences. We'll have it at 2. It's already 1. We'll have it at 2. 2 first item. Oh, first item no. Itu mati by prothom item ata ase no. 7 to mata bisor itu mati. 7. We'll do that and then. Madam. Ah, yes. Who is there for 19? Item number 19.
Last occasion, I was appointed as the amicus curiae.
Ah. You be here. Second half, we'll take it up. And Mr. You're Ahmed.
No, Chaudhary. A.
Chaudhary. You do one thing. You go through the medical report. The allegation is they were having physical intimacy. That was after promise to marry. But you go through the medical examination report, you will find that the hymen was intact. If that be so, the physical intimacy may not be there. And she got married also, subsequently within 4 months. You also, Mr. Sharma, just go through that. If that be so, the whole edifice of the prosecution case goes. And there is no clarification with regard to that. Know that. But even if it is 417, it is on behalf of that physical relationship maintained because of promise of promise.
There are certain things which I would like to point out, my lord.
Hmm.
Other things, my lord.
Hmm.
My lord, the seizure list which is there, my lord, in the 20.
Hmm.
There, my lord, if your lordship sees everywhere in the case, my lord, it has been mentioned regarding the iron rod,
Hmm.
where the
What was recovered was
a
bamboo, but a wooden.
log. That doesn't tally
But
with the.
something was recovered.
Doesn't tally with the thing, my lord, blunt object, my lord. And my lord, regarding the injury also, my lord, caused by a blunt object, not
Blunt
a sharp,
object.
not a sharp.
That is why 323.
Sharp object.
No dispute.
No dispute. And my lord, regarding the conviction, my lord, under 323, my lord, there was an alternate remedy, my lord, under the probation, my lord, that probation.
That is what we are going to give you.
3, my lord. And
That
my
is
lord,
what we are going to give you.
Otherwise, the fine, my
But
lord.
Mr. A. Fukan, learned counsel for the petitioner. For the amicus curiae appearing for A. Fukan, learned amicus curiae appearing for the petitioner. Also heard Mr. M.P. Goswami, learned.
With your lordship, appellate court, man, reduced 1 month.
No, the learned appellate court exonerated him from 341. A conviction of the appellant 323 upheld. There is no modification
No,
of the
that
sentence.
is what.
MP Goswami, additional public prosecutor appearing for the state. The present revision petition has been instituted. Assailing the judgment dated 19/9/2012 passed by the learned session judge in criminal appeal number 6/2/2011, dismissing the appeal and thereby upholding the conviction and sentencing of the petitioner 2323 IPC. And thereby upholding the judgment dated Oh 6/2011, passed by the Judicial Magistrate First Class Bilasi Para, to the extent of convicting the petitioner herein under Section 323 IPC and sentencing him to undergo imprisonment for 6 months, simple imprisonment for 6 months, along with a fine of ₹500 in default, to undergo further simple imprisonment for 1 month. So the prosecution case is, in brief, is that one Hazrat Ali lodged an FIR on 6/11/2006 before the officer in charge Bilasipara police station, inter alia alleging therein that on at around 9 a.m. of the same day, the accused persons named therein had raised altercation with them regarding domestic matter. It was further alleged that the nephew of the informant, while coming to Bilasipara with a motorcycle, the accused persons had wrongly restrained him, and thereafter his nephew was assaulted with an iron rod, causing grievous injury on his head. It was further alleged that his nephew, Yaqub Ali, had lost ₹2,000 at the place of occurrence. So, on receipt of the said FIR, the same was registered as Bilasipara PS case number 300/06. Also, on conclusion of the investigation, police laid a charge sheet against the petitioners herein under Section 341/326/34 IPC. Also, the learned trial court, upon appreciating the materials coming on record, proceeded to frame a charge under Section 341/326/34 against the petitioner herein and the other accused persons. Also, the charge being read over and explained to the accused person, they having pleaded not guilty and claimed to be tried, a trial ensued. Also, subpara, on conclusion of the trial, the learned trial court, by judgment dated 4/6/2011, proceeded to convict the petitioner herein under Section 341/323 IPC. Also, the learned trial court acquitted the other accused persons, namely Muhammad Jainur Islam, Muhammad Jahanuddin and Musammat MUSTTH. Sahera Beva, from the charges framed against them. Also, on his such conviction, the appellant was sentenced to undergo 6 months simple imprisonment and along with a fine of ₹500 for the offence under Section 323 IPC, in default of payment of fine, to undergo further simple imprisonment for 1 more month. The petitioner was further sentenced to 15 days simple imprisonment for the offence, along with the payment of fine of ₹200 in default to undergo further simple imprisonment for 15 days for the offence under section 341. Also, the petitioner herein being aggrieved by his conviction by the trial court assailed the judgment dated 4/6/2011 by way of filing an appeal, being criminal appeal number 6/2/2011 before the court of the learned session judge Dubri. The learned session judge Dubri, upon appreciating the evidences coming on record, was pleased to uphold the conviction of the petitioner, conviction and sentencing of the petitioner under section 323 IPC. Also, the learned trial appellate court, however, acquitted the appellant petitioner herein from the offence or from the charge framed against him under section 341 IPC. Also, being aggrieved, the petitioner has instituted the present proceedings. Also, I've heard the learned counsel for the parties and also perused the materials available on record. Also, on a perusal of the conclusions drawn by the learned trial court, this court finds that the learned trial court, upon appreciating the evidences coming on record, was of the view that the injury as sustained by the victim in the matter cannot be termed to be grievous in nature. However, the evidences having come on record of hurt being sustained by the victim, the learned trial court proceeded to hold that the charge against the petitioner under section 320 offense under proceeded to hold that an offense under section 323 IPC stood proved beyond reasonable doubt against the petitioner herein. Also, accordingly, further, the learned trial court also held that the petitioner herein, having wrongly restrained the victim, the offense under section 341 IPC was also proved beyond reasonable doubt against the petitioner herein. So, basing on the said conclusions, the learned trial court convicted the petitioner herein as follows. Page 23, A to A. Also, the learned the judgment passed by the learned trial court on being assailed before the appellate court-wide judgment dated 19/9/2012 was pleased to draw the following conclusions. Para 15, 16, 17, page 27, 28. Also, accordingly, the appellate court, while upholding the a perusal of the judgment passed by the appellate court, it is apparent that the appellate court, basing on an appreciation of the evidences coming on record, had upheld the conviction of the petitioner herein under section 323 IPC and had acquitted the petitioner herein from the charge framed against him under section 341 IPC. So this court has perused the conclusions drawn by the learned trial court as well as those drawn by the learned appellate court. On a perusal of the conclusions so drawn, this court is of the considered view that the conclusions drawn by the learned trial court as well as by the appellate court have been so drawn basing on a due and proper examination of the evidences coming on record, and no infirmity is found therein. Accordingly, the conviction of the appellant herein under section 323 IPC and his sentencing, conviction of the appellant herein under section 323 IPC would not mandate any interference. Having drawn the above conclusions, this court notices that the learned trial court, while proceeding to sentence the petitioner herein, had noticed the provisions of the Probation of Offenders Act 1958. However, noticing the nature of the offence committed by the petitioner, the benefits there under the said act thereunder was denied to be extended to the petitioner hearing. So, subfella. This court finds that the petitioner hearing this court finds that the offence in the matter was committed by the petitioner on Six 11/2006. Also, more than also around 19 years have lapsed since the commission of the offence by the petitioner in the matter. Also, the petitioner for the last 19 years have been litigating involved in litigation in the matter, initially before the trial court, thereafter before the appellate court, and presently before this court in the present revision petition. Also, accordingly, this court is of the considered view that the petitioner herein is entitled to be extended the benefit under the Probation of Offenders Act 1958. Baki? Okay. Before the appear before the full stop. This court not having interfered with the sentencing of fine as imposed by the learned trial court for the offence under section 323, the petitioner is required to deposit the same. Baki, it will take 1 month along with the deposit of money. He has suffered enough.
Evidence, my lord, they
Before the Chief Judicial Magistrate, Bilasipara. This court records its appreciation for the assistance rendered by Mr. A. Fukan, learned disposal of the present criminal.
Executed.
No talak is executed. This talak was not registered with the Muslim Marriages Divorce Act under the Muslim Marriages and Divorce Act. This is no talak in the eye of law. Yes. Yes, Mr. Hello. Can a talak without being registered? No, I want your assistance. Can a talak without being registered be a valid talak under the Act of 1935? Because that was holding the field then.
If they have agreed.
They have not agreed.
Accepted.
That talak would
Then
not
that
accepted.
If
Okay.
they have not accepted, then
As prayed for by the Learned Council for the parties, we'll have it. Then let him be in the presence of the petitioner also. Tell him. We'll have it on Thursday. On Thursday, huh? Thursday, but Friday, did you? Because without registration, it cannot be. For a valid talak to come about, it has to be registered.
Qazi Act 1980.
No, the Assam Muslim Marriages and Divorces Act 1935. No, that is not there today only. That was there then.
Not as per this marriage has not been done in that act.
No, but your divorce, Muslim marriages and divorces have to be registered, or it has to be before the court. Special Marriages Act.
Tried to send a notice, my lord, but I have not accepted.
Your acceptance is nothing, but they'll have to register that. Otherwise,
No registration took place.
We'll hear it. I may be wrong also. We'll hear it. Yes, Mr. Chaudhary. What did you get?
W5 is the doctor. And upon the was the 4 months of filing of the complaint petition, examination was done after 1 month of the 1 month of filing of the complaint.
Not that, not that, not that, not on that. Item number?
19. I have flag marked the PW5.
Have you seen the local examination? Just, it would be yes. The assault is on various, or at least on 4-5 occasions, right? 2-3 occasions. If that be so, what about this position, the underlying portion dust? That cannot be there. Or there has to be an explanation to that effect. Right? That cannot be. And there is no explanation to that effect.
On several times.
Several times. So
Several.
that cannot be.
Yeah.
That cannot be. And you have also not clarified that aspect from the IO, from the medical officer. If that be so, the whole allegation falls through.
The cross-part, my lord, that is not real.
Not there. No, why should the accused bring it? It is already in his favor. But nobody argued on that lines. I don't find any argument on that lines here. And you come to para. So, if 376 is not proved here, 417 will also not be proved.
But my lord, in public meeting, my lord, before my lord, public, he admitted that, and my lord,
That is
regarding that,
extrajudicial confession.
and my lord, PW,
And your allegation is, the allegation of the defense is, that is also not proved. That he was pressurized to marry her and that she was married, she was in love with her brother-in-law. But the evidence shows that there is no brother-in-law.
yes,
Because only brothers are there,
brothers,
no sisters.
person who the name of that person was similar.
That is not here. Where do I get it? Where do I get it? Forgesor.
Forget, sorry.
Forget.
But your name is Uttam. How can it be same? Don't go into all those slides. I'm only on that medical
Yes,
opinion.
yes.
Once it has been established, but that the prosecution has not proceeded and got a clarification. That way, so the very physical intimacy goes. And if that goes, 417 also cannot sustain. There was something between them brewing, but nothing happened. Was marriage fixed? Date of marriage fixed?
Ring
50,000,
ceremony fixed.
15,000. Your full name? Obhijit. Laha. heard Mr. Abhijit Chaudhary, learned amicus curiae, appearing for the appellant. Also heard Mr. B. Sharma, additional public prosecutor, appearing for the state. The present appeal has been instituted, assailing the judgment dated 12/9/2013, as by the learned session judge Bongaigaon in sessions case number 96 bracket Dangor BGN bracket over oblique 2012, convicting the petitioner herein under section 417 IPC and sentencing him to undergo rigorous imprisonment for 1 year, along with payment of fine of ₹1,000, in default to undergo further simple imprisonment for 2 months. The prosecution case in brief is that when was the FIR filed? FIR was lodged on
Complaint case was filed on.
Sumit's the prosecution case in brief is that Malati Burman had lodged a complaint on 14/2/2012 before the court of the Chief Judicial Magistrate Bongaigaon, with a prayer to forward the same to the officer in charge, Bongaigaon Police Station, for registering a case under section 376/417 IPC. Also, in the said complaint, it was alleged that the appellant herein, being a neighbor of the complainant, used to visit her house frequently and had developed intimacy. No. Malati Burman to Mark Penny. It's a mother. Malati Burman had lodged to Likha, visit her house and had developed intimacy with her minor daughter, who was projected to be aged about 15 years. So it was further alleged in the complaint that about 4 months ago, when the complainant and her husband were not present in the house, the appellant herein had come to their house and had induced and insisted her minor daughter to have physical relationship. Also, it was further projected in the complaint that although her minor daughter had refused the advances of the appellant herein, however, the appellant, on promising to marry her minor daughter, the minor daughter of the complainant, believing the same, allowed the appellant to have sexual intercourse with her. It was further alleged that the appellant had sexual intercourse with her daughter on several days. Also, the said complaint was registered as CR case number 25/2012. The learned CGM thereafter forwarded the same to the officer in charge of Bongaigaon Police Station. Full stop. On receipt of the said complaint, the same was treated as an FIR and registered as Bongaigaon PS case number 92/2012 under section 376/417 IPC. On conclusion of the investigation, the police laid a charge sheet against the appellant herein under section 376/417 IPC. Also, the case thereafter, on being committed to the court of the learned session judge Bongaigaon, the learned trial court, on perusal of on appreciating the materials available on record, framed a charge under section 376/417 IPC against the petitioner herein, against the appellant herein. Also, during the trial, the prosecution examined 9 witnesses, including the medical officer and the investigating officer. Thereafter, the appellant herein was examined under section 313 CRPC. Also, on conclusion of the trial, the learned appellate learned trial court, while judgment dated 12/9/2013, acquitted the petitioner, the appellant herein under from the charge framed against him under section 376. However, appreciating the materials coming on record, however, on appreciating the evidences coming on record, the learned trial court proceeded to convict the petitioner, the appellant herein under section 417 IPC. On a such conviction, the appellant herein was sentenced to undergo rigorous imprisonment for 1 year and also to pay a fine of ₹1,000, bracket ₹1,000, in default to undergo further simple imprisonment for 2 months. Being aggrieved, the petitioner has, being aggrieved, the appellant has instituted the also, Mr. A. Chaudhary, learned counsel for the learned amicus curiae, by taking this court through the evidences of the prosecution witnesses, has submitted that the allegations leveled against the petitioner herein by the victim who had deposed during the trial as PW does not find corroboration from the evidence of the medical officer who had examined the victim girl and who had deposed during the trial as PW PW5. Also, he submits that the allegation leveled by the victim girl, bracketed PW4, is to the effect that the appellant herein had committed sexual assault on her on various occasions. However, he submits that the same, if to be true, the deposition of the deposition of the doctor as PW5 must be held to be erroneous, to be not correct. However, the prosecution had not taken any steps for clarification with regard to the opinion rendered in the matter by the medical officer as PW5 during the trial. The learned Mr. A. Chaudhary further submits that the offense under section 376 being improbable in view of the evidences coming on record, improbable of having been committed by the appellant herein, in view of the evidences coming on record, the conviction of the appellant herein by the learned trial court under section 417 would not be sustainable, and this court would be required to interfere with the same. Right? Anything more? Also, Mr. B. Sharma, learned counsel for the learned additional public prosecutor, has submitted that although the allegation against the petitioner herein, against the appellant herein under section 376 was held to have not been established by the learned trial court, however, the evidences coming on record having demonstrated that the appellant herein had physical intimacy with the victim girl only on the ground of promise of marriage, and he having resiled therefrom, the offense under section 417 was proved beyond reasonable doubt, and the conviction of the appellant herein by the learned trial court under section 417 IPC accordingly would not mandate any interference from them. Right? I've heard the learned counsel for the parties and also perused the materials. Also, The victim girl, during her deposition, the victim girl in her deposition during the trial had deposed that the appellant herein used to visit their house as he was their neighbor. She further deposed that the appellant had revealed to her that he loved her and had also asked her to love him. Also, she further deposed that she did not love the appellant. Also, the PW4 further deposed that in absence of her parents from their house, the appellant had come to their house and committed some misdeeds towards her. She deposed that she had resisted him to do so, but he did not pay any heed to her request. Also, thereafter it was deposed that she informed the matter to her parents and a meeting was held amongst the villagers of their village. Also, in the village, please. Also, in the meeting, she deposed that she, along with the appellant, was present, and on being asked, she had disclosed before the villagers in the meeting that the accused had committed some misdeeds on her. Also, she further deposed that the people of their village fixed the date of their marriage, and one proceeding was also made in the said meeting. Also, however, the accused did not come to marry her. Also, she further deposed that the accused had committed the misdeeds towards her by giving assurance of marriage to her. Also, the PW4 also deposed that after around 4 months of the incident, she got married to another person, and the complaint was filed by her mother. Also, the perusal of the evidence of the PW4, along with the evidence of her father, of PW1 and PW3, would bring to the forefront that the victim girl herein was subjected to repeated sexual assault by the sexual intercourse by the appellant herein. However, on a perusal of the deposition of the doctor examining the victim girl, who had deposed as PW5 in the trial, brings to the forefront that nothing abnormal was found with regard to the petitioner on her examination. The doctor had further opined that it could not be ascertained as to whether she has been raped or not, and that the victim girl was above 18 years of age. A perusal of the findings recorded by the medical officer who had deposed as PW5 of the petitioner would reveal that the hymen, HYMEN dash, of the victim girl was found to be intact. It is found that the said aspect of the matter was not further clarified from PW5 by the prosecution in the matter. In the event accordingly, the opinion of rendered by the findings of the medical officer with regard to the victim girl stood intact. Also, accordingly, in view of the findings of the medical officer, the projection made by the victim girl of the appellant herein, subjecting her to repeated sexual intercourse, is rendered improbable. Also, in view of the said contradictory evidences coming on record, the evidence of the victim girl being rendered improbable, comma, a doubt having also arisen in the matter, comma, this court is of the considered view that the same has to be extended to the appellant herein. Also, the learned trial court, although for reasons other than what has been noticed herein above, had held the appellant to be not guilty of the offence under section 376. Also, the said reasoning has been noticed, and in view of the reasons noticed herein above, comma, this court upholds the conclusions of the learned trial court, acquitting the appellant herein under from the offence under section from the charge under section charge framed against him under section 3, although for the reasons noticed herein above. Also, the commission of sexual intercourse by the appellant herein upon the victim girl having been held by this court to be improbable in view of the evidences coming on record, more particularly the evidence rendered in the matter by the doctor examining her as PW5, comma, this court is of the considered view that the charge under section 417 IPC cannot be held to be established against the petitioner herein. Against the appellant herein. Accordingly, for the reasons cited above, the conviction of the appellant herein under section 417 IPC and his sentencing thereunder would mandate an interference. Full stop. In view of the above discussions, this court proceeds to interfere with the judgment dated 12/9/2013 passed by the learned trial court in sessions case number 96 bracketed BGN/2012. So the petitioner is acquitted of the charge under section 417 and he is set at liberty. The bail bonds executed by the petitioner by the appellant herein stands discharged. With the above observations and directions, the present stands allowed. Registry to send down their records along with a copy. So, before parting with the records, this court records its appreciation for the assistance rendered towards disposal of this court of this appeal by Mr. Abhijit Chaudhary as an amicus curiae in the matter. No, we have fixed it. He says that the thing has not been executed. Now you also
They have accepted.
no, you also tell me whether it was registered.
I have tried to contact him, but he's not.
You just get it. We'll have it when we have fixed it. Friday.
Friday.
Friday. Just get that instruction because under the 35 Act it has to be registered.
It's not registered. Necessarily not necessary. Talak.
That is clear.
Talak.
To Qazi it was sent, so there is no.
No. It has to be registered.
Now maybe
No. Under the 35 Act, you just
35
explain.
is registered, but
You just
Qazi, no,
examine that aspect. Just examine that
notice is
aspect.
conveyed, man. That is the.
No. You will have to register. Compulsory
I've done
registration.
that act where also says 1935 act.
35 Act. There is compulsory registration. Yes, Mr. Mazhavia, that is compulsorily registerable.
Apart from that, they 125.
Senior man, he knows.
Learn it. Here also, we also know.
I have already talked to him. I've
But it's
already
not-
taken his opinion.
Actually, correct, man. It's actually not applied, my actually, normally. Only the Qazi notices are
Oh,
sent,
no.
and once conveyed.
That we will not.
35 Act itself give the authority to Qazi.
To register. No, you will have to appear before the Qazi. He will then see whether you are, that has been done in a manner required, and then he will register. It's only after registration it will done. Qazi has got no role in the divorce. His role comes only in registration. You check up
125 proceeding, he said that.
that he'll get the instructions. No proceeding. No proceeding. You just clarify this because that finding we will have to deal with.
Fine.
could not make any contact.
Okay, heard Mr. D. Diffusa.
Yes, S. Diffusa, Your Lordship.
Huh?
S. Diffusa.
S. Diffusa, learned counsel appearing for the learned counsel for the petitioner. Also heard Mr. J. Chutia, learned counsel appearing for the respondent number 1. None has appeared for the respondent number 2 and 3. Also, the present review petition, criminal petition has been instituted assailing the proceeding has been instituted praying for quashing the proceedings under criminal complaint quash the proceedings instituted by the respondent number 2 before the Chief Judicial Magistrate. It has been instituted praying for quashing of the complaint case instituted by the respondent number 2 before the Chief Judicial Magistrate Kamrup, which is registered as CR case number 3638 bracket uporodata C thaki oblique 2013. Also, the respondent number 2 herein as complainant had instituted a complaint case being CR case number 3638 oblique 2013 before the Court of the Learned Chief Judicial Magistrate Kamrup, inter alia alleging therein that on 27/10/2013 at about 11:30 hours, the respondents, that is the petitioners herein, along with some others, had forcefully entered into their residence and had demolished a portion of their boundary wall with the intention to grab their land. Also, it was further alleged that when she, along with her brother, tried to prevent the petitioners herein, they had threatened the complainant of using force to force them to leave Torun Nagar. Also, it was further alleged in the complaint that the petitioners herein had used flitty language and had also abused her sister-in-law, Prabhati Jaiswal. Also, the complainant in the complaint further alleged that her brother, Krishna Jaiswal, on the same day had gone to the Bhangagar police station to lodge an FIR, but till 28/10/2013, the police did not register the same, and as they were living in constant fear, they had approached the Honorable Court by way or Learned Court by way of instituting the complaint case. Also, it is seen that the Learned Trial Court had recorded the deposition of the complainant under section 200 and thereafter also examined the witnesses and had cognizance was taken and had taken cognizance of the matter of the complaint of the offense and issued notices to the present petitioners. Also, accordingly, the present petitioners being aggrieved had instituted the present proceeding. Accordingly, the petitioners herein being aggrieved had instituted the present proceedings. I've heard the Learned Counsel for the parties and also perused the materials available on record. The Learned Counsel for the petitioner has submitted that the matter involves dispute civil in nature, and accordingly the present complaint accordingly the complaint case instituted by the respondent number 2 would not be maintainable. He further submits that the petitioners, barring the petitioner number 6, are members were members of the Torun Nagar Mahila Samiti, no, Torun Nagar Unnayan Samiti, and they had only used their, and they had only tried to reconcile between the respondent number 2 and her other family members who had a dispute with regard to the possession of the land in question. Also, she further submits that the brother of the respondent number 2 is a party here, Krishna Jaiswal,
Yes, yes, yes.
that the respondent number 3, petitioner submits that the respondent number 3 was a signatory to the compromise arrived at between the family members of the respondent number 2 and 3 and had undertaken to withdraw the complaint case pending before the court of the Dana Chief Judicial Magistrate Kamrup. However, the same was not complied with and leading and requiring the present petitioners to approach this court.
Most importantly, Your Worship, in the
Also, accordingly, he submits in the Learned Council for the petitioners, in the above premises, submits that the proceedings in CR case number 3638/2013 would be required to be quashed by this court. Full stop. None has entered appearance on behalf of the complainant, that is the respondent number 2 and the respondent number 3 herein. Also, I have heard the Learned Council for the parties and also perused the materials available on record. While the Learned Council for the petitioner has projected that the dispute involved is of a civil nature and the same to be existing between the respondent number 2 and 3 and their other relatives pertaining to the possession of the land in question, this court on examination of the complaint petition finds that the allegation leveled against the present petitioners is with regard to the forcible entry into the residence of the respondent number 2 and 3 by the petitioners, and also of demolition of a portion of their boundary wall, which was projected to be with the intention to grab, which was projected to be with the intention to grab the land of the respondent number 2 and 3. Also, the above being the position, a criminal act having been committed in the matter by the petitioners here, this court is of the considered view that the complaint case as instituted in the matter by the respondent number 2, herein, would not mandate to be interfered at this stage. The petitioners have the opportunity to place their stand before the learned trial court and to pray before the learned trial court for dismissal of the complaint case in the manner known to law. Also, in view of the above conclusions, this court is of the considered view that the present criminal petition would not be maintainable, present criminal petition to be devoid of any merit, and accordingly the same stands dismissed. The interim order passed by this court, wide order dated 2020.02.2014 stands vacated. Also, registry to forward a copy of the present order to the learned CGM Kamrup bracketed Metro for information and necessary action. With the above observations and directions, the present criminal petition stands dismissed.
obliged.
Yes. Mm.
Appellants are two in number.
Mm. Two charges.
Is para 34. But in entirety, I sentenced Elias Abdul Rahman to suffer RI for 1 year, a fine of rupees 5. All RI and RI for 3. The informant was an advocate in
And he was hit. The informant, the advocate was hit. Advocate was assaulted.
yes, whatever, my lord, this advocate was involved in so many cases. During this pendency of this case, she is murdered. No more now.
Eh?
Already murdered.
Is no more.
But when there are so many cases against her, she was in jail also for 56 connection with some case. Yes, this accuser also alleging that this government advocate was involved in murder of their brother. There are other cases also against, and the
King.
Okay, my lord. With this lady advocate, she was so daring, and she got involved in so many matters.
She is gone, let her go. We'll not discuss anything about her.
So, my lord, what happened? Apparently the evidence of PW1, that is the informant, and the other, I have given this some description of the couple and assault and some
The
injury.
victim is PW1.
PW1, my lord.
Simple injury was sustained by this the informant and another person. So, to that extent, my lord, I have seen this examination was also done. Some minor discrepancy. The 13 years passed.
When
This
was the incident? 17/1/2011.
of probation of offenders.
Perhaps, my lord, this may not be case of probation, my lord. One statement,
She is very, very elaborate.
very elaborate, and that has been while PW2 went there to take her, my lord.
He was also assaulted.
Also hit, my lord, and he statements of PW1.
But the injury is simple, caused by sharp weapon.
Sharp weapon, my lord. And the doctor's evidence has examined 2-1 and PW2. Here, my elaborately, my lord, doctor is described by them. Their witnesses supports X, my lord, attempt to life on harm. One is one
The motive is also, as told by the Learned Council,
Yes,
the
my lord.
motive is also very
It's
clear.
also clear, my lord. Now, my lord.
Whether it was proper, improper, that's a
That
different
is
thing
just a
altogether. But
difference. One
you can
year-
only concentrate on the materials before me. I can't go beyond
Yes,
this.
my lord, that is.
Mintu is second one,
Second one, he was
Saga. But he only gave a kick.
he did the crime, my lord, and but main assault and accused number one.
Jumma. The conviction is only 323.
Yes.
Under 323.
As a
Others all acquitted. Attempt to murder was there, 341 was there, but finally it is 323. Hey, Abdur Rahman was also convicted under 323 only.
Yeah.
323.
Just come to the sentencing. 34, 35.
Para 34. So having considered the matter in entirety, I sentence Elias Abdur Rahman to suffer RI for 1 year.
So this is under 323. Now just see 323.
Other also 320.
Other is okay. Please see 323. Sharma, Mr. Goswami, just have 323 for my clarification. Punishment is
Imprisonment for 1 year or fine of 1,000 rupees or both.
so. How can it be more than 1,000? Can it be? It's 1 year,
5,000.
1 year and 5,000. Just can it be given? Because the maximum is
The
1,000.
maximum,
1,000, it cannot go beyond that. Neither without India. So, can it be 5,000? It should be 1,000 only. What we do is that we will maintain the fine part, condone the imprisonment.
Obligement.
But Mr. Alam, you are M. Alam,
Yeah,
A. Alam, learned counsel for the petition for the appellant. Also heard Mr. MP Goswami, learned counsel, learned additional public prosecutor appearing for the state. Also, the present appeal has been instituted by the appellant herein, assailing the judgment dated 26/5/2016 passed by the learned additional session judge Borpeta in sessions case number 17/2015, convicting there are two appellants here, convicting the appellants herein under section 323 IPC and sentencing them accordingly. Full stop. The prosecution story in brief is that the appellants herein a story in brief is that informant Rinima Begum had on 17/1/2011 lodged an FIR. Before which police station?
Borpeta.
Before the officer in charge Borpeta police station, inter alia alleging therein that on that day at around 5:30-6 p.m., the appellants herein had forcibly dragged her away from the side of the road near Borpeta Bhandar and had assaulted her by stabbing her with a dagger, and thereby inflicted injuries upon her person. She further alleged that in the FIR, it was further alleged that the appellants herein had attempted to kill the informant and accordingly stabbed her one after the other. She also alleged that the appellants herein, in course of the act done by them, had caused injuries to one bystander, namely Ajit Das. Also, the FIR further projected that the accused person had fled away from the place of occurrence subsequent to gathering of a public at large in the place. Also, the police, on completion of the investigation, laid a charge sheet against the present appellants under section 341/307 IPC. Also, during the trial, how many witnesses? 11. During the trial, the prosecution examined 11 witnesses, including the medical officer and the investigating officer. Also, thereafter, the appellants herein were examined under section 313 CRPC. Also, on conclusion of the trial, the learned trial court, by judgment dated 26/5/2016, while proceeding to acquit the petitioners herein from the charge under section 341/307/334 IPC on the benefit of doubt, proceeded to convict the petitioners, appellants herein under section 323 and sentence them accordingly. Charge sheet laid corruption. The learned trial court, on the matter being committed to it, appreciating the materials coming on record, had framed a charge under section 341/307/324/34 IPC against the appellants herein, and the same on being read over and explained to them, the appellants having pleaded not guilty and claimed to be tried, a trial ensued. Hajar, on conclusion of the trial, Hikimi. Also, being aggrieved with the conviction by the learned trial court, the appellants have instituted of Mr. A. Alam, learned counsel for the appellant, after taking this court through the evidences, through the deposition of the witnesses during the trial, more particularly the deposition of victims as PW1 and PW2, has fairly submitted that although there are certain inconsistencies in the deposition of the witnesses, the same are minor, and he fairly submits that the conviction of the appellants herein would, under section 323 IPC, would not mandate interference. He, however, submits that the offense committed by the petitioners, by the appellants herein, was so committed on 17/1/2011, and around 14 years having lapsed since the date of commission of the said offense, were you behind bars at any point of time?
Verify, my lord.
He submits that this court would be pleased to leniently consider the sentencing of the appellants herein.
Section of
Outside. No, but after charge sheet, after the trial, they had come up here only for 323. Okay. This order was stayed by this court. Mr. MP Goswami, per contra, Mr. MP Goswami, learned counsel for the appellant, for the state, learned additional public prosecutor appearing for the state, submits that the evidences coming on record having established beyond reasonable doubt the offense committed by the appellants herein under section 323 IPC, and the assault as committed by them upon the informant not being the assault committed by them upon the informant being established, the conviction of the appellants herein under section 323 IPC by the learned trial court would not mandate any interference. Also, I have considered the evidence, the submissions made by the learned counsel for the parties and also perused the materials coming on record. The learned trial court upon Okay. Okay. The learned trial court upon conclusion, upon considering the evidences coming on record, had drawn the following conclusions. Para 26, page 16. Thirty, 31. Okay, 31. Thirty-two, 33. Huh? So, upon drawing the said conclusions, the learned trial court proceeded to sentence the petitioners herein, the appellants herein as follows: 34 and 35. Huh? Also, I have perused the conclusions drawn by the learned appellate court in the light of the evidences coming on record and find that the conclusions by the learned trial to be based on a proper and due appreciation of the evidences coming on record and no infirmity is found therein. Also, the conclusions drawn by the learned trial court for acquitting the present appellants from the charge framed against them under section 341/324/34 IPC would also not mandate any interference. Also, likewise, the conviction of the appellants herein under section 323 IPC in the considered view of this court would also not mandate any interference. Also, in view of the above position, the conviction of the appellants herein under section 323 IPC stands affirmed. Full stop. This court, having drawn the above conclusions, has noticed the sentencing of the appellants herein and finds that the appellant number 1 was sentenced to suffer rigorous imprisonment for 1 year and to pay a fine of rupees 5,000 in default, rigorous imprisonment for further 3 months for the offence under section 323 IPC. This court, on a perusal of provisions of section 323 IPC, finds that the same mandates for a term of imprisonment which may extend to 1 year or with fine which may extend to 1,000 rupees. Accordingly, the fine amount imposed by the learned trial court of rupees 5,000 in excess of what has been mandated under the provisions of section 323, and no reasoning has been advanced for the said fine amount of rupees 5,000 as imposed upon the appellant number 1 by the learned trial court. First, this court also notices that the offence in the matter was committed on 17/1/2011 and around 14 years have lapsed since the date of commission of the offence in the matter by the appellant here. Also, considering the fact that considering the long lapse of time occasioning in the matter, and also noticing that the appellants herein were litigating in the matter for the last around 14 years, initially before the trial court and presently before this court in the present appeal, this court is of the considered view that the sentencing of the appellant by the learned trial court would mandate a modification. Also, in this connection, this court has perused the provisions of section 323. For the said provisions of section 323 being relevant, The same is extracted here in below. So a perusal of the provisions of section 323, which mandates punishment for voluntarily causing hurt, provides for a term of imprisonment of either description, which may extend to 1 year, or with fine, which may extend to 1,000 rupees, or with both. Also, section 323 having mandated alternative punishment, that is imprisonment or fine or both, this court is of the considered view that considering the long lapse of time occasioning in the matter since the date of commission of the offence by the appellants herein, ends of justice would be meant would be met in the event would be met by modifying the sentencing of the petition trial court to that of imposition of a fine of ₹1,000, in default to undergo rigorous imprisonment for further 3 months in respect of both the 1,000 each, in respect of both the appellants herein under section 323 IPC. So, with the above modifications with regard to the sentencing of the petitioners herein, the present appeal stands disposed of. Registry to send down the records, along with a copy of this order for. Also, appellants to appear before the learned trial court within a period of 30 days from today to deposit the fine amount.
My pair regarding the.
I've said that. Per contra, you have said that. You have said because of the materials on record, the conviction and sentencing need not be interfered with. আরো সাইডা আছে না দি দিয়া ভিতর তোমার ভিতরে দি দিয়াচোন চাওঁ কি কৰো তোমাৰ কেইটা হ'ল দুটা হ'ল নেকি এটা হৈছে আৰু এটা লোৱা Okay, we'll pass the orders. You need not wait.